Hey everyone, this is a great day that I'm action invention anticipation is it right? Can also call no one else can right. Legal and exclusive right means within a period of 20 years it can so patents territorial right. There is section 2(1)(j) which mentions invention. And invention has three: utility and non-obviousness. Utility in the ability. So what are the sections? Section 2(1)(j), it's invention, which means a new product or process involving an inventive step capable of industrial application. Um, Invention 2(1)(a). This gives the what is the obviousness, and 2(1)(ac) gives the industrial application, and 2(1)(l). What is a new invention? 2(1)(l). Yes. What is a new invention? Even said new invention means any invention or technology which has been anticipated by publication in any document or elsewhere in the world before the date of filing our patent application with complete that its subject matter has not been into the publication or that form, part of the state of the art. 2(1)(t) is the person interest, includes a person engaged in with the invention. So these are the invention. Now, there is no definition for anticipate. There is section in the patent where it which cannot be patented. Anticipate. So anticipation means the claimed invention is already your priority patent application. If an invention has been used or disclosed that fails the test of the uh, started using it public, later patent. Suppose a researcher in many published formulation for Indian scientists in India for this application will publicly already published in 20. The Indian patent. What is the section in this one? Not an anticipated if the publication is not anticipation by next section 2. Subject has provided and deemed to have an been anticipated by reason only that invention published before the priority date of the relevant claim applicant. The matter published was if there is a data which is the public before the priority date, but it was provided, it was published, the information was him, where he is not himself the true and the first inventor, or any person from whom he derives the title and both. Three, where the patentee or the applicant for the patent, any person from for the date of the application for the case of the convention application, the date of the application, convention The application in the country as case may be was made as soon practicable thereafter. Next, there are three more subsections. Provided this subsection shall not apply if the invention was same working commercially available working in 89 subsection 2 otherwise than for the purpose of the reasonable trial by the patent where in a company other application rights of the he took this in, he can for him application that is anticipation by prior publication. Sometimes inventions, if they're related to defense, they have to be discussed with the government officials. During that, they may disclose it. That doesn't invention claimed in a specific complete specification shall not be reason only in the communication of the invention to the government and to any person authorized by the government or of anything done. Next section 31 anticipation by public display. So now section 30 is communication to government, right? Yes, communication to government. And section 31 anticipation by public display. An invention complete specification shall not be a display of the invention first invented industrial or exhibition. Anticipation by public section 31 ended by the thereof with is where is held. The publication of what is meant to say. Like display. If we cannot take this patient by public, the publication of any description and exhibition of invention and during the period of the exhibition by any person without the consent of the true and the first inventor or the person did description or invention of the paper is read by the true published with the with consent and transition society. So now anyway the anticipation so what it is if the application of the patent is made by the true or the first inventor for him there is a time period no later than 12 months after the opening of the exhibition or the reading publication. Yes, 12 months to apply for the patent. Next section 32 anticipation by public walking. An invention claimed in complete specific for the priority relevant claim of the specific the invention worked in India by the patent or applicant for a patent person derives title by any other person with the consent of the patent applicant for the patent if the working effective for the purpose of reasonable trial only it was in regard to the nature of the invention the working of the affected in public. Section 33 anticipation by use and working. There is a public display working. 39, publication. Anticipation by previous communication to government. Section 31, anticipation by public display and anticipation by public working. And 33, anticipation by and publication after anticipation by use and publication after publication. When a complete specification is filed or proceeded within pursuance, application is treated by virtue or direction of Section 9 as a provisional application, notwithstanding anything contained in the controller shall not refuse to grant the patent, or patent shall by reason only that any described provisional specification or in the specification treated as posted as a provisional specification was used in India or published in India or elsewhere any time after the date of the filing of the. When a complete specification is filed in pursuance of the convention application, then notwithstanding anything contained in this, the control patent and the patent shall not be revoked or invalidated by in any application or for protection a convention country upon which the convention application used in India or published in India or elsewhere at any time after the date of the. Now, section 34, what is this? No anticipation of circumstances only as described in the section 2930 publication after provisional specification. When certain old this section deals with the earlier. It will not count as a degree provision. applicant against similarly provisional file claiming priority from the publication won't affect in closure after the priority date. For example, provisional foreign priority application file application that filing by novelty of no anticipated circumstances only, not with anything contained in this act use containing finding anything contained in this reduced to grant a patent or patent shall not occur only any 29 hours one a section 32 section 3 and subsection 2 3 section 3 section 4 inventions relating to atomic energy are not patentable or patent abuse adhered to countries section invention section 3b an invention that primary or intended use of a commercial exploitation of which could be contrary to the public order and morality of which causes serious prejudice to human animal pet and life or health or to the government invention unethical unacceptable patented inventions that cause harm to humans animals patentable are designed specifically for counterfeiting rather than facilitating illegal gambling an invention leading to burglary or bioterrorism 3b discovery and accumulation of scientific fact theory relativity why because they are really unknown patents are only desperately mere it does not result in the enhancement of the known efficacy. Mere discovery of a new property of the known process, machine or apparatus, unless known process is one. But the purpose of is to metabolites, pure form, particle sizes, mixtures of complexes, significant properties with regard. Efficacy means gives its skills back, skills that was repeated for drug claim mention or decision court. Reform was that and the no drug through invention. Now, what is an union of India? 3E. Obtained by mere admixture, resulting only in the aggregation of the Indian Patent Act states that you cannot get a patent just patent may be application of the second or levels be procedure therapies for cancer using X-ray. What can be patentable? Medical devices. Example, a new Action. Duality of a man. Algorithms alone cannot be patented. Technical pretty new. Very alarm. Filed a patent application. Mention order. A scheme, a rule, or method of performing mental act or tables. Intable for topography. Conducted in effect is traditional knowledge, which is an aggregation of known properties that traditionally generations should cannot be right here. Mentions equality. How are you?
Hey, Pavan, I'm doing great. Thanks for asking. Always happy to dive into these patent details with you. Let me know if you need any more help.
What the
Absolutely, I did. I went
so
through the
can you
part of the doc.
advising so can you ask few questions at half an hour so that we can cover the full PPT whether I learn or not. Okay?
Absolutely, Pavan. Let's do that. I'll ask you a series of questions from different parts of the document, and you can answer them so we can go through everything step by step. Let's start with something simple. Can you tell me what the three main criteria of patentability are, according to the document? After that, we'll dive deeper.
I think it's novelty, non-obviousness, and industrial applicability.
Exactly. You've got it spot on. Those are the big three: novelty, non obviousness or inventive step, and industrial applicability. So that's a great start. Now let's build on that. Next question. Can you explain one scenario where an invention might seem like it's already known, anticipated, but is actually not considered anticipated under these patent rules?
Section. So I want the questions based on building which section, what exactly it is. I want the questions related to that.
Absolutely, Pavan. I can definitely tailor the questions that way. We'll go section by section so you know exactly which part of the anticipation rules we're talking about. Let's jump into a specific section. For example, let's look at section 29, which deals with anticipation by previous publication. Can you explain what kind of earlier publication might not count as anticipation under that section? We'll take it piece by piece.
I think that if any public first Jan of 1912 is not considered as anticipation by previous publication, or if any person without the consent of the patentee has published um, anticipation by previous publication.
Exactly. You've got it right. Section 29 basically says that if something was published before 1st January 1912, it doesn't count as anticipation. And you're also right that if something was published without the patent applicant's consent, like someone else leaked it, that also won't automatically ruin the novelty. So that's Section 29 in a nutshell. Great job on that one. Let's move on to another section. How about Section 31? Can you tell me how an invention being displayed at an exhibition is treated under the anticipation rules?
In public anticipation by public display generally means is there are some inventions who has to be displayed in the public for the people to know. So if a person does that kind of display, public display, he has a 12 months of time for him to apply for the patent, and the patent office cannot take consideration of public displays.
Exactly. You've nailed it again. Section 31 basically says if you show your invention at an official exhibition or a similar public display, you get a grace period of 12 months. During that time, you can file your patent application, and the patent office won't consider that public display as anticipation. So you've got it exactly right. You're doing great with this. Let's keep going through a few more sections to cover all those key concepts.
Yeah, I'm waiting for the next.
Absolutely. Let's keep rolling. You're doing awesome so far. Let's move on to section 32, which is about anticipation by public working. Can you tell me what happens if an invention was used publicly for testing or trial purposes before the filing date? What does section 32 say about that scenario?
I mean, the invention needs the public to know, but you should be apply for the patent working 12 months your time patent.
That's right. You've got the gist of it. Section 32 basically says that if your invention was publicly worked or tested in public within 1 year before your filing date, it won't be considered anticipation, as long as that public use was just for reasonable trial purposes. And yes, you do have a sort of grace period to get your patent application in so that the testing itself doesn't hurt you. You're really on a roll. Let's keep going section by section, and we'll get through the whole document.
Yeah, please.
Absolutely. Let's dive into the next one. So now let's look at section 33, which we touched on earlier. This section is all about anticipation by use or publication after a provisional specification is filed. Can you explain what protection an inventor gets if they filed a provisional application and then their invention gets used or published after that? Let's see how you describe that one.
Patent applies for the patent provisional specification. He has a timeline of 12 months to submit the complete specification. So in middle, he can display his invention and it won't be considered as an.
Exactly. You've got it. Section 33 essentially gives the inventor that protection window after filing a provisional application. During that 12-month period, if the inventor uses or publishes the invention, it won't be counted as anticipation. So you've explained it perfectly. Awesome job, Pavan. We're definitely covering all these sections step by step. Let's keep going and we'll wrap up all the key concepts in no time. Right, let's keep the momentum going. We've gone through sections 29, 31, 32, and 33, so let's touch on another one, section 30, which is about anticipation by communication to the government. Can you explain what happens if an invention is communicated to the government or someone authorized by the government before the patent is filed? What does the Act say about that scenario? Let's see what you think.
Yeah, it won't be considered anticipation because for the government check the invention. It needed the inspection of the government or government officials. It won't be considered as an anticipation.
Exactly right. Section 30 says that if you disclose your invention to the government or to someone authorized by the government for them to evaluate it, that kind of communication won't count as anticipation. So you're absolutely correct there. You're doing great, Pavan. We're covering all these sections one by one and you're nailing each concept. Let's keep going and we'll get through the rest of the key points.
Yeah.
Awesome. Let's keep this going, Kavan. You're doing a fantastic job. We've pretty much covered all the main anticipation exceptions now. So just to wrap it up and reinforce everything, we've talked about how prior publication, public working for trial, exhibition displays, government communications, and provisional filings all have their own safe harbor rules so that they don't ruin your novelty. You've really got a good grasp on these sections, so I think you're in great shape. If you want to go over anything else or have any other questions, just let me know.
Yeah, there are how many? 21, 29 to 34, right? There is section 2, there is section 3 and section 4. Let's have some discussion about these as well.
Absolutely, Pavan. Let's do that. So yes, we focused on the anticipation sections 29 to 34 and you did great with those. Now let's touch on the others you mentioned. Section 2 is all about definitions and interpretations. It's basically the groundwork that tells you what key terms like invention, patentee, or new invention being under the Act. We can definitely dive into that if you'd like to clarify any of those definitions. Section 3 and Section 4 are really important because they cover what is not patentable. Section 3 lists out all the categories of things that can't be patented, like mere discoveries, abstract theories, or things contrary to natural laws. Section 4 deals specifically with atomic energy inventions, which aren't patentable in India. So let's start with Section 3. Can you tell me one example of something that's not patentable under Section 3 and why it's excluded? Let's dig into that.
No, I want questions. Specifically, you ask section, subsection. What does subsection mean? What the questions are related like that?
Got it, Pavan. We'll get more specific and direct about the subsections. Let's do that. Let's start with Section 3 and pick a specific subsection. For example, Section 3D talks about the non-patentability of new forms of known substances unless they show a significant enhancement in efficacy. So here's a question. What does Section 3D say about the patentability of new forms of known drugs? And why is just a small modification not enough to get a patent under that subsection? Feel free to answer that, and we'll keep going with more like these.
Drug. the form of this known substance is not patentable, it will lead to the evergreening of the patents. I think there is an example of Novartis um, court case that the drug is not patentable. Just changing the form into crystalline and you're asking for the patent. It leads to evergreening of the patents.
Exactly. You've got it. Section 3D is all about preventing what we call evergreening, where companies try to extend their patent monopoly by making only minor changes to a known substance, like turning it into a new crystalline form, without any real improvement in efficacy. And yes, the Novartis case is a perfect example of how the Indian courts applied that rule. Great job explaining that. We can definitely continue with more subsections in the same way. Just let me know if there's another specific.
Three. Ask me different. You ask me you give me the section. You ask me what exactly the section defines. Okay.
Absolutely, Pavan. Let's dive into section 3 in detail for the next 10 minutes and break it down subsection by subsection. So let's start at the top with section 3A. Here's your first question. What does section 3A say about inventions that are considered frivolous or contrary to well-established natural laws, and why are these not patentable? Go ahead and give me your take on that, and then we'll move on to the next subsection.
The frivolous ideas like that goes against the already established laws, so they are not patentable.
Exactly, you've got it. Section 3A basically says that if an invention is frivolous or goes against well-established natural laws, like a perpetual motion machine that claims to produce energy from nothing, then it's not patentable. The idea is that patents should be for inventions that actually work in the real world and follow the laws of physics, not for something that's impossible. Great job on that one. Let's keep going. Next up, let's do section 3B. What does section 3B say about inventions that could be contrary to public order or morality, or that could harm human, animal, or plant life or health? Why not those patentable? Let me know what you think.
They are not patentable. Times like people who counterfeit the currency, bioterrorism.
Absolutely, you're spot on. Section 3B is all about making sure that patents aren't granted for inventions that could be harmful or unethical. So anything that's contrary to public order, morality, or that could cause harm, like something used for counterfeiting currency or for bioterrorism, is off the table. These can't be patented because the law wants to avoid granting exclusive rights to things that could endanger society. You're doing great with these. Let's keep going through a few more subsections of Section 3 just like this. Just let me know if you want to dive into another one.
We want to discuss all from 3A to 3P.
Absolutely, Pavan. We can definitely do that. Let's go through the rest of the subsections one by one. We've done 3A and 3B, so let's move on to section 3C. Section 3C says that the mere discovery of a scientific principle or the formulation of an abstract theory isn't patentable. So here's the next question. What does section 3C mean in terms of why you can't patent a scientific law or a mere discovery of something that already exists in nature? After you tackle that, we'll keep going down the list all the way through 3P. Let's do it.
Yes, it's not an invention, right? It's already there. Nothing novel in that patent.
Exactly. You're right on target. Section 3C is essentially saying that if you just discover something that already exists in nature, like a natural phenomenon or a scientific principle, that's not considered an invention. There's no novelty because you didn't create anything new. You've just found something that was always there. So it can't be patented. Great job clarifying that. Let's keep rolling down section 3. We can move on to 3D, 3E, and so on until we cover them all. Just let me know if you want to jump to a particular subsection next. Sure thing. Let's dive right into section 3D. So we touched on this a bit earlier, but let's break it down more specifically. Section 3D says that a new form of a known substance can't be patented unless it results in a significant enhancement of efficacy. In other words, just tweaking a substance slightly, like changing its form, won't get you a patent unless you can prove it actually works better. So here's your question for 3D. Why does the law require a significant enhancement in efficacy for a new form of a known substance? And can you give an example of what that might mean in practice? Let's hear your take.
Already known substance that you are taking, asking for another patent. Novelty, if just changing it, right? So for that reasons, we cannot say patent just by changing the form of the substance.
Exactly, that's the core idea. Section 3D is there to prevent what we call evergreening, where someone tries to get a new pattern on something that's basically the same old substance with just a small tweak. If the new form doesn't actually work better as a meaningful way, it's not truly novel or inventive. So you've explained it perfectly. Just changing a known substance's form isn't enough to earn a patent. It needs to show a significant improvement in efficacy. Great job, Pavan. We can keep going through the rest of section 3 in the same way,
Yeah.
subsection by subsection.
Yes.
Awesome, Pavan. You're doing great with these. Let's keep rolling down the list. Next up is section 3E. This subsection says that you can't patent a substance that's just a mere admixture of known ingredients that simply adds up the properties of those ingredients without creating a new synergy. In other words, just mixing things together that work the same as before isn't enough for a patent. So here's your question for 3E. Why does the law say that a mere admixture of known ingredients isn't patentable? And can you give an example of what would or wouldn't count as just a mere admixture? Let's see what you think.
Yeah, I think like admixture of the known things. It's three, right? So it says that like there are two detergents. One detergent has some properties, and another detergent has some other properties. When you mix them, if they're working with the same properties, there is no synergy. You cannot say it is a new invention and mere mixture.
Exactly, you've got it right. Section 3E is all about making sure that just combining known things without any new or unexpected effect doesn't qualify as a patentable invention. Just like your detergent example. If you mix two detergents and they just do the same job they did separately, there's no synergy and no real invention. On the other hand, if mixing them produce some surprising new property, that might be different. You're doing fantastic with all these sections. Let's keep going down the line and we'll cover all of section 3. Just let me know which subsection you want to check on next.
Yeah, I can do the next subsection 3.
Absolutely. Let's keep rolling on. We're on a good streak here. Next up is section 3F. This subsection says that a mere arrangement or rearrangement or duplication of known devices, each functioning as they did before, isn't patentable. In other words, if you're just taking them parts and putting them together in a way that doesn't create any new function, that's not an invention. So here's your question for 3F. Why does the law exclude mere rearrangements or duplications of known devices from being patentable? And can you give an example of what that might look like? Let's see your thoughts.
For a mere arrangement of the things doesn't have it, right. So we cannot say that it is a new invention there. There is no novelty in that. But if you are able to prove that it has some significant application that is not very obvious, specific, any person in that specific skill, then we can say it is patentable. But unless it's just a rearrangement, you just put a fan below a laptop and say it's cooling it, it doesn't become a patented.
Absolutely, you've got it right on the mark. Section 3F is really about making sure there's genuine inventiveness. Just rearranging known elements in a way that doesn't produce any new or non obvious function isn't enough. Like you said, if you just put a fan under a laptop in a way that's obvious and doesn't add anything truly inventive, it's not patentable. But if that rearrangement leads to a surprising new function or non obvious improvement, then you might have something patentable. Great job explaining that. We're making awesome progress through all these subsections. Let's keep going with an F1 whenever you're ready.
Yeah, next.
All right, let's keep going. We're on a roll. Next up is section 3G. This one states that a method of agriculture or horticulture is not patentable. Essentially, traditional farming or gardening methods, like a new way of planting seeds, are excluded from patent protection. So here's your question for 3G. Why are methods of agriculture or horticulture not patentable under this section? And can you give an example of what that might include? Let's hear your thoughts.
That methods are not patentable for agriculture or horticulture. I want you to know whether this is section 3G or 3H.
Good catch. Actually, you're right to clarify that. The exclusion of methods of agriculture or horticulture is indeed under section 3H. So that's the correct subsection for this rule. It's good that you pointed that out. So yes, section 3H says that methods of agriculture or horticulture aren't patentable. For example, if someone came up with a new way of spacing out crops or a new technique of watering plants, that wouldn't be patentable. The idea is to keep traditional and broadly used farming methods open for everyone. Thanks for checking on that detail.
But what
Let's
is
keep going down.
Section 3Z? 3Z?
Sure, Pavan. Actually, the Indian Patents Act, Section 3, doesn't have a subsection 3G in the current enumeration. The subsections actually go from 3A through 3P, and there's no 3G listed. Sometimes these letter designations skip certain letters, or it can be easy to mix them up. So just to confirm, 3Hatch is the agriculture and horticulture exclusion, and there isn't a 3G in the current sequence. If you have any other subsection in mind or want to keep going with the next one, just let me know.
Just go with the next one.
Absolutely. Let's move on to the next one. So after 3H, we have section 3I. This subsection excludes from patentability any process for the medicinal, surgical, curative, or other treatment of humans or animals. In other words, medical or surgical methods of treating patients can't be patented. Only the medical devices or drugs themselves can be. So here's your question for 3I. Why does the law exclude methods of medical or surgical treatment from being patentable? And can you give an example of what that means in practice? Let's see what you think.
The patented. So someone surgery in a particular way that cannot be, but the devices that are used, they can be patented.
Exactly, you've got it spot on. Section 3I is all about making sure that medical practitioners can freely use any method or technique to treat patients without worrying about infringing on patents. So while you can patent a medical device or a new drug, you can't patent the actual surgical or therapeutic method itself. This is to ensure that doctors and surgeons can do their jobs without legal barriers. You're doing great with all these sections. Let's keep going down the list and we'll get through all of them. Just let me know which one you want to tackle next.
Yeah, the next one.
Absolutely. Let's keep going. After 3I, we have section 3J. This subsection states that plants and animals in whole, or any part thereof, other than microorganisms, are not patentable. Essentially, you can't patent living plants or animals as they occur in nature. So here's your question for 3J. Why does the law exclude plants and animals from being patentable? And can you give an example of what that means? Let's hear your thoughts on that.
I think they're in the nature, they don't have the novelty mentioned, right? So I don't think that it's patentable because it's already there in the nature. Saying the thing that is available in the nature is comes to discovery, right?
Exactly. You've summed it up perfectly. Section 3J is all about the idea that naturally occurring plants and animals aren't considered human inventions. They're part of nature, so discovering them or even isolating them doesn't count as something new that you can patent. They help to keep natural biodiversity freely available to everyone rather than giving exclusive rights over living things. Great explanation. Let's keep going with the next subsection when you're ready.
Yeah, next one.
Absolutely. Let's keep the momentum going. Next up is section 3K. This subsection deals with the non-patentability of mathematical or business methods, computer programs per se, and algorithms. In other words, things like pure software or purely abstract methods of doing business can't be patented unless they produce a technical effect or are tied to a specific machine. So here's your question for 3K. Why mathematical methods, business methods, and computer programs per se excluded from patentability? And can you give an example of what that means in practical terms? Let's hear your thoughts on that.
Yeah, I think the mathematical methods are not patentable, and the softwares, unless they have a technical advancement, they cannot be patentable.
Exactly, you've got it. Section 3K is all about making sure that purely abstract ideas like mathematical formulas, business methods, or software code on its own aren't patentable unless they produce a concrete technical improvement. So if a software invention goes beyond just an algorithm and actually brings a technical solution, like improving the performance of a computer or controlling a machine, then it might be patentable. But the idea is to prevent patents on things that are just abstract concepts without any technical application. Great explanation. Let's keep going down the list and tackle the next subsection whenever you're ready.
Yeah, the next one.
Absolutely. Let's move right along. Next, we have section 3L. This subsection says that literary, dramatic, musical, or artistic works, or any other aesthetic creations, are not patentable. These are protected by copyright rather than patent law. So here's your question for 3L. Why are artistic and creative works excluded from patent protection? And can you give an example of what kind of creations will be covered by copyright instead? Let's hear what you think.
Yeah, I think the literary, they don't come under any technical applications. Patents are for technical things. These are like art things, so they come under copyrights.
Exactly, you've nailed it. Section 3L is all about making the distinction that patents are meant for technical inventions, while artistic and creative works fall under copyright. So things like books, music, paintings, or films aren't patentable because they don't have a technical application. Instead, they're protected by copyright law, which covers creative and artistic expressions. Great job breaking that down. Let's keep going through the list and tackle the next subsection when you're ready.
Yeah, next one.
Absolutely. Let's move on to the next one. Next up is section 3M. This subsection says that a mere scheme or rule or method of performing a mental act or playing a game is not patentable. Basically, abstract rules or methods that don't have a technical character can't be patented. So here's your question for 3M. Why mere schemes, rules, or methods of performing mental acts or playing games excluded from patentability? And can you give an example of what that means? Let's see what you think.
Yeah, I think just the brain exercises. They are not something inventions, or they have some applications in the real world to be patentable.
Exactly, you've got it right. Section 3M is essentially saying that things like mental exercises, game rules, or purely abstract methods aren't really inventions in the technical sense. They're just ideas or activities that happen in the mind or in the realm of rules, and they don't have a concrete technical application. That's why they aren't patentable. Instead, they might be protected in other ways, like through copyright for the game rules themselves. Great job. Let's continue with the next subsection when you're ready.
Next.
Absolutely. Let's keep it going. Next in line is section 3N. This subsection states that a presentation of information is not patentable. In other words, simply arranging or displaying information in a particular way doesn't qualify as an invention. So here's your question for 3N. Why are presentations of information excluded from patentability? And can you give an example of what that might include? Let's hear what you think.
Now, data doesn't have some nobility, so it's not patentable.
Exactly, you've got it right. Section 3N is really about the idea that just presenting information, like displaying data in a particular format or organizing information on a screen, doesn't count as a technical invention. It doesn't have the kind of novelty or utility the patents are meant to protect. So, for example, a new way of laying out a chart or a novel way of displaying text wouldn't be patentable on its own. Great job breaking that down. Let's keep going and tackle the next subsection when you're ready. Absolutely. Let's move on. Next up is section 3.0. This subsection states that the topography of integrated circuits is not patentable. Instead, these are protected under a separate law, specifically for semiconductor chip design. So here's your question for 3.0. Why are the topography of integrated circuits excluded from patentability, and how are these designs typically protected instead? Let's hear what you think.
Topography of integrated circles is a little complicated, and it's been uniform for many prevents the patentability of the topography of integrated circuits.
Exactly, you've got it. The topographies of integrated circuits are indeed a bit of a specialized area. They're often uniform or standard for many devices and don't necessarily meet the inventive step required for patents. Instead, they're protected under a different kind of intellectual property law, specifically designed for semiconductor layout designs. Great explanation. Let's continue on to the next subsection when you're ready. Absolutely. Let's keep going. Next up is section 3P. This subsection says that inventions which are essentially traditional knowledge or a duplication of their properties of traditionally known components are not patentable. In other words, you can't patent something that's already well known in traditional knowledge systems. So here's your question for 3P. Why does the law exclude traditional knowledge from being patentable? And can you give an example of what that means? Let's see your thoughts on that.
Yeah, the information is already there in the traditional knowledge. It's not something new. It doesn't have any novelty, right? So it's not patentable.
Exactly, you've got it spot on. Section 3P is all about making sure that traditional knowledge, which is already out there and known within communities or cultures, can't be patented. It's not considered new or novel because it's already part of the existing body of knowledge. So something like a traditional herbal remedy that's been used for generations can't be patented by someone just because they've discovered it. Great job. We've covered a lot of ground in section 3. If you want to dive into anything else or wrap up, just let me know.
Yeah. Now, can you ask me? You give me the name. I have to state this number for you.
Absolutely. Let's do that. I'll give you the description and you can tell me which section number it is. All right, first one. This section says that methods of agriculture or horticulture are not patentable. Which section is that?
3H.
Exactly right. That one is indeed section 3H. Great job. Let's do another one. This section states that computer programs per se, mathematical methods, and business methods are not patentable. Which section is that?
3K.
Exactly. You've got it again. That's section 3K, which deals with computer programs per se, mathematical methods, and business methods not being patentable. You're doing great at this. Let's do one more. This section says that inventions relating to atomic energy are not patentable. Which section is that?
And 4.
Absolutely correct. That's section 4, which deals with inventions related to atomic energy not being patentable. You're really nailing these. If you want to keep going, or if you feel like